It's going to be a fairly quick list, over 4 hours, so I'll try and introduce you to the archives, how we operate, what we do, how you can use us, and what we hold. Hopefully your church will get prepared enough on there, and we'll have a chance to look to you. Okay, so I'm from Brigg archives, and we're a county council function, but we also act as the diocesan record office, so we hold records from the diocesan registry. And we're also the appointed place deposit for broker records, so we hold records from a lot of you guys. We're based in St Ronald Street in Lincoln, and we're open 5 days a week, Tuesday to Saturday, between 10 and 4. And we recommend making an appointment beforehand because we can't guarantee there'll be a place for you physically if you don't. It's very contact details, I'll leave these up at the end. The important one is find the County Council website, look for archives on there, and you'll be able to find the links to everything else on there. And for those of you who don't know where we are, we're in the middle of Lincoln. If you're coming north, we're to the right-hand side of Broadgate, so you have to go around the whole walkway system to get to us. There is a car park at the back of the building, and you have to come off that off-road lane, which is just to the side. It's not very big, so it can fill up, but there are plenty of other car parks nearby. We're about 5 minutes walk from the station, the bus station, so we're fairly well located. And if you haven't been to us before, you'll need to get a reader ticket so you can actually get into the search room. And there's a couple of forms to fill in, very basic details, name and address, sign the agree to behave yourself. We do ask for proof of who you are, so what we like is then proof of signature and proof of address. So the driver licence is perfect, otherwise some official documentation, the address on, the bank card with the signature on, and we'll get you sorted. And when you're done, you get issued with a little blue card that's valid for 4 years, so you can then come and go if you like. This is a fairly national ticket, so you may have got one from another office elsewhere, in which case we just ask you to fill in one of the 2 forms, and we'll see it with the because what we hold can be up to 800 years old, unique, precious, irreplaceable, we do ask people just to use pencils when they're in the archives. We don't want any accidental annotations, and it can affect the legality of things if there are. So bring along a pencil, rubber, and a small notepad, and a laptop if you want to use one. Once you're inside, the search room holds about 40 people at a time, which is why we make the appointments sometimes. The key bits you'd be interested in are the tables where you look at documents. But most importantly, there's a large map table, which you have 2 people at a time working on. And some of the things you might look at can be very, very big, so you'll probably need to book that if you're going to be starting to look at Tithe and Enclosure. And the ways of finding these things vary from parish to parish. All the records are kept well behind the scenes. You don't get to actually go on the shelves to get them off yourselves. So you need to get a reference number and fill in a slip in order for our staff to retrieve documents for you. To find the references, there are card indexes, there are TypeScript catalogues, there's computer catalogues. None of them are entirely complete, so you probably have to look in several different places just to make sure you've covered all options. But hopefully you'll come up with some references and dates of the document that you need. There are separate card indexes, there's one for Tithe, one for Enclosure, so you can go straight to those. They're fairly well maintained, those 2, although cards occasionally go walkies. That should help you. It's always worth looking at other finding areas as well. The staff there will guide you towards the most relevant bits, especially if you're doing chance liability research. I'm going to bring some more. We operate a slip system for actually requesting documents. That means our staff can then go find it on the shelf and put the slip where it comes from, so we know it's going to be back in afterwards. There's several boxes you need to fill in. The most important one is the document reference. Without that, we won't have a clue what we're looking for. The date you need it, that's usually the same day, but it could be a week in advance if you're coming back. Your name, And the reader ticket number, which we can give you, the table you're on, which proves you've actually got a table, and then there's something called the collection number, which I'll come to in a second. And there's a blue box there that says document description. It's not mandatory, but if you're after a map, it's usually helpful to put it on there, because then the staff know they're looking for something big. The forms are in triplicates, they're self-carbonated, so you just write on the top one fairly firmly. The back has got a pink one. Pull that off, that keeps a record of what you've ordered, with references, etc. You then put it through a little post box on the front desk, and then keep an eye on some charts on the wall, and they'll tell you when it's ready for collection. The time it takes to get something out can vary. We usually try and collect the slips every half hour, but if you happen to put your slips in 1 minute after the last collection, then obviously you'll have to wait a bit longer. On a quiet day, it could come a lot faster. On a busy day, it might slow down. So bear in mind, it's not going to be instantaneous. Various sources have been mentioned, of course, today, particularly Tithe and Enclosure. There are a few others that might be useful. You might want to look through PCC minutes or Confession minutes, looking for precedents. Glebe Terriers sometimes mentioned Tathwell, etc. But the Tithe and the Enclosure are the main ones we need to look at. As mentioned, they can be very big. That's why you need a very large map table. That one's a sheet, not actually a tile map, but there are ones bigger than that that we've got. They are a nightmare to use because the written part of it is sewn to the map. So it's probably in the middle. So you have to actually use a ladder to actually reach out to the middle of the table to read it. They're usually very large scale. The one I bought from Alfred over there is a sheet because that's like a little ruler. But quite often the field is the size of a 50p piece, so if you've got a big parish, it can be huge. Particularly given the shape of some of the parishes down the south of the county, round the Witham Valley, they can be very long and thin as well. Not every parish is represented, usually because the one was never made. Sometimes only part of the parish is shown, such as with the marketplace one over there. And it could be, for reasons of history, particularly what one was missing from that series. We're fortunate the archives have got 2 separate series of these Tithe records. Originally 3 sets were created. One was kept by the Tithe Commissioners, which is now the National Archives. One set was given to the diocese, which has come to us over the years, and the other set was given to the individual parishes. And a lot of those are coming in from parish churches over the years, and they're in the parish deposits. So again, example of a Tithe map, that's quite a nice one. I won't go into great details with the written apportionment is usually tabular form, so it's fairly easy to use. Same can't be said for the enclosures. Date-wise, the enclosures are usually between the 1770s and 1830s. The prime purpose was to realign fields and roads, but tithes were dealt with as a sideline. Not every parish is represented. Sometimes the maps have gone missing over the years, sometimes the map survives and there's no award. We have got a book, it's a series of small-scale and survey maps that a geography lecturer from Exeter annotated with the location and sort of boundaries of each of the maps that we've got together with references. So sometimes that's quite a good way of seeing if there's a map that covers your particular area. Quite a good example there. Usually if it's a green area, that means it's ancient enclosures and not really covered by the award. The early ones are on huge parchment sheets, quite often stitched end to end in a single sentence that can be 30 foot long or something. They're a bit of a nightmare to read, put it mildly. The handwriting can be fairly atrocious, even though it's carefully written. There are little bits at the left-hand side that usually give you an idea of where you are in relation to things. So you can see the road section, so you can use all that to move onto the bits. But not easy to use by any imagination. Later ones tend to be in book format, tend to be a bit more tabular, a lot easier to use. Quickly look at other sources, things like Glebe Terriers. I mean, that one there mentions church repaired by the parish and chancelled by Mr. John Brownlow. Find Mr. John Brownlow's legal heirs, it's sorted for you. Never that easy. average graphics department with a very sophisticated camera that can take maps up to about that big, very, very detailed. So if you need a sort of legally certified copy, we can do that. You can also take your own digital cameras in. All we ask is that you switch off the flash, because that can damage the documents. And if you turn off the sound as well, it's great, because it doesn't interrupt other people's line of thoughts. We normally charge £5.20 a day for people to use the cameras, but that excludes depositors. So if you represent the parish, we won't charge you for looking at the parish records. I'm quite happy to extend that to the diocese records, because it's all part of the same thing. So we won't charge you for doing this research, but just make sure you mention at the outset that you're taking pictures as part of this chancel liability on behalf of the parish, and we'll just sign the form to say fee waived. So it's up to the money. So that's a quick whiz through the actual site itself, but it might be worth having a look before a visit on something called Links to the Past, which is our online catalogues. A lot of the time with enclosed material, I've put the catalogue references up on there, so you can do a bit of a search beforehand to see what you need. It's best to use the advanced search function and just try combinations of words such as enclosure and your parish name, or Tithe and parish name. And you'll start to get hit lists of the documents. So the one to use, you click on the advanced search option, there's some tabs at the top there. And there's an option that says with all the words. So basically put in your keywords there, click on the search button down the bottom, and hopefully you'll start getting a hit list of references that may or may not be relevant. Work through that list, filter it down if you need to, using the right-hand column, which can sort of rule out some of the less important ones. If you find something that looks relevant, click on the title, and it should open up an actual catalogue entry. That one won't go into great detail, but it does say the reference, so it's Lindsay Award 112, you know it's Market Roads and Enclosure Award Plan, 9th of October 1781, and it's held in the archives. So on all that information, you can come to us in order to do it. So there's the contact details. I think that's the important things I have to say. How are we doing for time? Okay. Any quick questions I can probably handle, otherwise I'll let Carol go. Sarah.
How much is certified copies?
I should know, I don't. I write the things, but I've only ever written 2 in my entire 12 years, so I think there might be a couple of quid on top of the copying cost. They're not vast amounts of money. I'm just sitting right at the back, which is the trick.
Same question.
If we're able to get document references off the website, can we order before we come?
You can do, yes. If you phone the customer service centre there is a separate email called archive booking. You can send it to the main archive email, just a list of what it was on the day, and that would mean they're ready for when you're here. But just make sure it's the same day as the you're looking for. Okay.
Before the passing of the Land Registration Act and up to date, chancel repair liability has been what's technically called an overriding interest. The perceived difficulty with that is that the person buying the land would not have notice of that from the title deeds or from the Land Registry record. The philosophy underlying the 2002 Act was that the Land Registry record should, as far as possible, be a complete record of the burdens that affect that land. And that's why we're in the position that we are in today. For the future, once the deadline has passed, the intention is to protect future purchasers of that land from buying unaware of the obligations that they take on. With that in view, the Act provided that there will be a 10-year period within which those overriding interests, including chancel repair, should be registered. That period expires at midnight on the 12th of October this year. What are the implications of that? Well, I can tell you that the first implication is this. If by that date you have not registered the PCC's liability, and that land is purchased by somebody for value. The liability is then not enforceable against them. The second downside is that if you seek to register after that date, the land registry will charge you a fee. At the moment, there is no fee payable for submitting the application to the land registry for their service. If you miss the deadline, it's not necessarily the end of the work, but you must get your application in as soon as possible after that, because you are at risk. The risk is that if the land changes hands for value, you will not be able to enforce that liability. The land registry's view of that at the moment is that the acquisition of the land should be at full market value, although I think there's scope for debate on that. If the land is simply gifted or inherited, that doesn't affect the position. You would still be able to claim. But the advice must be that you should get the application in and get it registered before the deadline. That's the best advice that you can have. You've done your research. We've explored in some detail today what you need to do. You've identified the land that carries the burden of the chancel repair liability. What do you need to do next to get it on the register? The first thing that you need to do is find out whether the title to that land is registered at the land registry or it isn't. Particularly in rural areas, there's still quite a lot of land which is not registered. And that impacts on the registration process. The way in which you achieve that is this. You submit an index map search to the land registry with a map, a proper, decent scale map showing the land that you're looking to register. They will then provide you with a search result which will list all the title numbers for the registered land within that area. At that point, you're looking at getting official copy entries of those titles for two reasons. Firstly, you need to check that there are no entries within that registered title already protecting the chancel repair liability. In some cases, there may be. Secondly, you will need the title number in order to effect the registration. There is now an alternative which, in the case of large applications, you might wish to consider. The land registry has a special services department which is called the Value Added Service, and they have recently introduced a new manorial plans service which operates out of Birkenhead. A lady called Pam White can be contacted. If you choose to explore that and you send them the plan of the land that you wish to register, they will digitalise that plan, produce a large specific search plan, and will identify the title numbers within that area. It may or may not be cheaper in each case than using the conventional route, but if you ask them what you want to achieve, they can give you a quotation for doing that. They may also be able to help you with a spreadsheet. Once you have identified whether the land is registered or not, you will know what sort of application you need to submit. If the land is not registered, then you need to lodge a caution against first registration. There is a form for that, Form CT1. The effect of lodging a caution is limited. What it entitles you to is notice if somebody submits an application to register that land. The land registry will send you notice of that. At that point, you would need to have to demonstrate that you have the right that you claimed. So you don't need to submit your evidence to the land registry when you put in the registration to enter a caution. Once that application has been registered, the person who owns that land will be given notice of the caution. They then have the opportunity to, in effect, ward off that caution by applying to the land registry for it to be cancelled. And again, at that point, you need to have your evidence available so that you can put it in pretty quickly. If the land is already registered, there's a registered title to it, then you can either apply to register what's called a unilateral notice or an agreed notice. The unilateral notice doesn't need the consent of the landowner. You don't need to submit your application when you put it, your evidence when you put your application in. The registrar will accept that application and the note will be put on the title. The landowner will be notified that that has been done. Again, all that achieves is to alert future purchasers of that land that there is a potential claim. It doesn't mean and doesn't acknowledge that that claim is valid or enforceable. That's a separate issue. The landowner at any time has the opportunity to apply to cancel that application, that notice. And he may or she may choose to do so. At that point, again, you have to put in your evidence. The other alternative is to apply for what is called an agreed notice. Something of a misnomer, because there are two ways in which that can be registered. You either obtain the consent of the landowner, in which case the process is quite straightforward, or you adduce to the registrar, i.e. to the land registry, sufficient evidence to satisfy him that your claim for chancel repair is valid. That gives you a slightly stronger degree of protection, because once you've done that, that can only be cancelled if someone demonstrates to the satisfaction of the registrar that that liability has ceased, or produces further conclusive evidence that it's invalid. You may be interested to know that the anecdotal information from the land registry is that to date, the majority of applications have been unilateral notices. Well, what happens once you've got that notice registered? Two things. Firstly, you need to make sure that you have the evidence there to support it if you're called upon to do so. And secondly, you need to make sure that you register with the land registry and address the service where any notices that they choose to serve are definitely going to be picked up. I say that for a very important reason. If, for example, you obtain registration of a caution or a notice, and somebody applies to cancel that, or somebody applies for first registration, you will be given notice of that. That notice will contain a deadline by which you must act. If the PCC fail to do so, and they miss that deadline, then the entry will be cancelled. That has quite serious implications. Once a registration has been made, chancel repair liability loses its overriding status. That status is not recovered if that entry is cancelled. You've lost it. Clergy, members of the PCC change. So you need to make sure that there is an address with the land registry to which they send a notice and where it will definitely be found and picked up. What are the implications if you've failed to register your notice in time and there's been a transfer of land? I've explained to you briefly the position in relation to transfers of value. Value need not necessarily be money. It might be that there's an exchange of land, or that there is somebody who takes over a debt equal in value to the land. It's not inconceivable that some landowner with a potentially substantial chancel repair liability, for example, organised an exchange with another family member for value, with a view to extinguishing that liability. So those possibilities need to be borne in mind. The land registry are generally quite helpful at the moment in terms of these applications. What they will not do, however, is provide you with evidence of the land which is burdened by the chancel repair liability, and you'd be surprised the number of people who phone up the land registry and see if they will help with that. It's beyond their remit. The question of plans, again, is quite critical. The land registry these days are generally quite particular about the plans that they will accept. However, if the quality of the tithe map is reasonable, in the case of chance or repair liability, if they can reconcile that with a modern OS plan, then they will generally do so. And certainly the senior officers recommend that that is what they do. Your difficulty is then if the tithe map is of such poor quality that you have to prepare a better plan so that the land can be identified. The Land Registry do publish some practice guides for the assistance of people seeking to register overriding interests. Those are practice guides 22 and 66, and they can be downloaded from the internet. 66 is aimed more at the professional practitioner than the layperson, but you may find it of assistance. You may be interested to know that it is not just chance or repair liability that is producing this sort of an issue. The Church Commissioners and the Crown Estates, for example, are busy registering manorial rights in relation to minerals. So your position is not unique, although the background is rather more complicated. What happens if you want to enforce your chance or repair liability? Well, you serve a notice on the person who is liable, and you might well be advised to take professional assistance when you do so. If that person declines to pay, the way forward is then through the county court, because the obligation is enforceable as a statutory obligation. The county court has a limited jurisdiction in terms of value, but in complicated cases like Aston Cadwell, it may well be referred to a higher court. You may well wonder what you've done to have all this inflicted upon you, and why title deeds to land in the registry record don't have a nice little entry that says it's subject to chance or repair liability. I think the answer to that lies in the original nature of the liability, which was a personal liability of the landowner. So technically it wasn't a burden or a land charge, and therefore in most cases it didn't appear on the deeds. That presented a little bit of a problem when they came to pass the Land Registration Act in 1925 as to what they did with it. So they classified it as an overriding interest, and that position is reflected in how we're now having to deal with it under the new legislation. The Bishop this morning said it would be nice if we had a magic wand and we could wave it and all this would have gone away. When the 2002 Act was drafted, a lot of people rather hoped that there would be a magic wand, and the draftsman originally thought that the Aston Cadwell case was going to go the other way, which would have solved a lot of problems for a lot of people. It didn't happen, and rather hurriedly they had to amend the drafts to provide for what was to happen to the chance or repair liability. I mentioned that just by way of background. Given my fairly limited time, I think that's all I need to say, but I will be happy to discuss any points that people wish to raise. Yeah.
Given what you've said about names and addresses changing over time, would it be reasonable and acceptable to provide as a service address the diocesan registry?
I think you should have someone providing their consent, which I think they may well be, then yes.
If you do your research and you discover there's no chance for repair liability residing on any land, does that have to be registered?
No. So the liability that you're looking to register.
I just said that if you do your research and find there's no chance for repair liability on any land, do you have to register it?
No, you don't. It's the liability that you're looking to register.
You do nothing.
We've got something like 35 different bits of land that each need to be separately registered.
You can submit an application to register which lists all the titles that you're looking to register against as one document, and the Land Registry should process that. If the land is unregistered, you submit your application to Apportionment, then you will attach a plan to that which will show the entire area, and they should register that portion. Any other questions I'll be happy to take later. Gentlemen there. Well, I think that's the point that Caroline's going to address very shortly in her next presentation. Thank you.
You've been bombarded with a huge amount of information today. I think it was a tour de force by Brigg to pack so much complex information into such a short space. You've been told time and time again that it is your obligation as PCC members to do something. And I just want to go back to what is it that your obligation is and what are you going to do about it. You've heard already, you know that you are, as PCC members, the PCC is a charity and the members of the PCC are charity trustees. Going right back to basics, the duty of charity trustees is to act in the best interests of their charity. So when it comes to this issue of chancel repair liability, it's not what's in the best interests of PCC members, it's what's in the best interests of the PCC. And the starting point has got to be that if the PCC has an entitlement to money, and potentially to very large sums of money, then the PCC members must do everything that is possible and reasonable for them to do to secure that entitlement. Now, the Charity Commission have issued guidance on this. I was interested to hear that Brigg is getting involved with PCCs who are getting responses from the Charity Commission. Their latest guidance does say that it is up to you to justify your position and they won't enter into correspondence. They clearly are, but you've got to bear in mind that you do take the risk that you might write to them and they may simply write back and say, jolly well done, it's up to you to decide whether that's the right thing or not. So what is the right thing? Well, the right thing is that the trustees, PCC members, have to act honestly and reasonably. And the decision that they make has got to be reasonable within a range of possible decisions that a sensible PCC would make. So if anybody comes along to you later and says, why did you behave like that? You can justify what you did. What that does mean, I think quite clearly, is the very first starting point is doing nothing is not an option. It cannot be an option. Now, you may falter at the first hurdle. You may say, look, we've got a PCC that's barely alive. We've got 3 members, 2 of them are aged 97. I work full time. I haven't a hope of getting this research done. We as a PCC simply cannot do this research ourselves. I think if you're going to go down that route and say, well, let's not do anything because we can't do it, I think you have got to at least say, what else can we do to get this research done? I think you have got to talk to your parishioners, put something in the parish magazine, put a flyer through the doors if that's a practical proposition, talk to other neighbouring parishes, you might be in a multi-parish benefice, talk to people in the deanery to see if there is someone else who will help you put this research together. And there are strange people out there, and I hesitate to say this in the same sentence, but I saw how enthusiastic Brigg was about chancel repair liability. There are people out there who love this. And I must say, from my own reading of people's bits of paper that they've brought into me, you learn an awful lot about your community that's nothing to do with chancel repair liability. It can be very interesting. So I think you, at the very least, got to show that you have made the effort, record in your PCC minutes of your PCC meeting, we can't do any of this research because we have tried to find someone to do the research for us. This is what we did to try and find someone. This was the outcome of what we did. And of course, the third option is you could pay somebody. Now, I know that Mike has one or two contacts at the Lincoln Archives. The National Archives website has professional researchers. You've heard Gregg's opinion of them. He can do the research himself. Your opinion of them may not be quite the same. You know, there are people out there who will do this research, who are professionals and will do it for a fee. The third hurdle, you may say, well, we haven't actually got any money. So I think you need to record in your PCC minutes. We looked into the cost of getting a researcher. It costs this much money. Our resources are that much money, therefore we can't afford it. You've got to go through the hurdle of actually justifying why you haven't done anything at all. I think for most PCCs it will be possible to do something, and if you, in the welter of information you've had today, if you don't do anything else but take that first slide Greg put up, not Henry VIII, but the first list of what he thought every PCC must do, if you do nothing else but do that, I think you will have started down the road of doing the right thing. Now, what Greg tried to do this morning was to cover every possible permutation of chance of repair liability that there might be. Now, I guess what you'll take away from this is there are lots of different possibilities. I think if you try and look at the big picture, it is mind-blowing, and I find it mind-blowing, and I've spent a lot of time researching this, and as Greg said, you could never be an expert, because every time you think you've cracked it, something else comes up that is completely impenetrable. If you take Greg's slide and do these things one step at a time, it is actually surprising. And I've seen documentation that people have brought into my office to look through. Sometimes the answer is surprisingly easy. Easy answer number one, there is no chance of repair liability. You might find, you may be lucky, you may find that out very quickly. Easy answer number two is there is chance of repair liability. Look, we found the land on the plan. It's in a field that's got a wonky corner. Look, if you look on the Modern OS map, you can see exactly the same field with the same wonky corner. It's really easy to identify what the land is and to get it registered. Now, it may be that you go down some of these roads and you actually find that the answer gets far too complicated. And some of these things that Greg raised about, this takes a lot of research, this might be difficult, and you may stumble at that hurdle. But I think you've got to go through the effort, well, I don't think you have, it seems to me, to comply with the law, to go through it step by step and see where you get to. Now, Greg, I think, felt quite strongly about the reality of is anybody going to make a claim against you? Well, who might make a claim against you? Is it theoretical? I think for most PCCs it perhaps is theoretical. But aren't you going to look pretty stupid when something ghastly happens to your chancel in 5 years' time, and you find there's a problem that's going to cost you perhaps £1 million, perhaps £100,000, £250,000 to repair, that somebody in your community who doesn't much like you, and we've all got them in our communities, and one of the things I spend an awful lot of time dealing with is people who've fallen out with other people in their community and really want to have a go at the PCC members and tell them they behave badly. Someone in your community discovers that actually, had you bothered to do basic research, you would have discovered that some large body was responsible for 100% of the liability, and that it was British Waterways or some body that you weren't going to destroy your mission by registering against, and you just didn't do anything. Now, if we all had crystal balls and the benefit of hindsight, you'd know whether it was your parish or not. We just don't know. And you are taking that risk that who's going to bring the claim? Well, it can be done one of two ways. The PCC itself is a corporate body and therefore can bring claims in its own name. So the PCC would have the right to sue former members of the PCC to say, we haven't got these assets anymore, it's your fault, you didn't do anything. That might happen. And in a community where you've got people who've fallen out with one another, that could be a very real possibility. The Charity Commission have also got a right to take action against against charity trustees who have failed in their duty. So you could have it coming at it right away. People might report you to the Charity Commission. So what are you actually going to do to show that you've behaved honestly and reasonably? Well, you do the research, you get as far as you can. If you're very fortunate, you may find actually the research is perfectly straightforward. You are one of the great 20-minute cases, you can get it all done and get it all put together. You've then got to you may then get to the point where you say, well, we've done all the research, it isn't actually very straightforward. We've got some big landowners, we've got some small landowners. You've then got to solemnly sit in your PCC meeting and make a decision and make a justified decision and record your reasons. So you might say, we've established, I think the example Brigg gave was the field where the liability would have amounted to £5.44 in a £1 million case, and it's now 12 houses. You need to solemnly record that you have considered that, and you have considered that on cost grounds it is not worth pursuing. Actually keep a record. If you're going to go down the route of saying that it's damaging to ministry and mission, and if we do this, as Gregory's example, people won't come to our church, or people won't get married in our church, I think as far as you possibly can, you have to have some reason for saying that. I don't think you can just sit in your PCC meeting and say, do you know what, if we actually went out into the world and told people about this, they wouldn't like it. I think you've got to go out into the world and talk to people about it. I think you've actually got to ask people how they feel about it, maybe talk to the lay rectors, see what their reaction is. Sometimes, I know it's been quite clear, so again, some of the things that I've seen that have come over the desk, is you've got a whole range of situations. You've got some parishes that already know who all their lay rectors are, have a relationship with their lay rectors, and have been claiming against them for years, and it's just a question of recording what already exists. I've also come across parishes where they pretty much know who their lay rectors are, and it's pretty easy to prove. And the lay rectors are going, it might be us, it might not. And actually, if you went and said, no, honestly, you know this, you don't you? We are going to have to do something about this. They'll go, oh, all right then. And there won't be any damage done. You've also got to bear in mind that, as Brigg mentioned again this morning, that I guess what my colleagues who do conveyancing put me right, but for at least the last 10, 15 years, when property has changed hands, most solicitors acting in conveyancing matters will have done one of these chancel research checks. They're not worth an awful lot in terms of what they tell you, but what you get back as a result saying, this property is at risk, this property isn't at risk. In any situation where it highlights that a property is at risk, it is most mortgage lenders' practice to require insurance to be taken out. So there will be an awful lot of people out there, and they may be the ones who have only got little properties, but there are an awful lot of people out there who will be insured and will not have to put their hands in their pockets to pay for this. So mission isn't going to be damaged with them. Now, if you can, the best example is if you can get a situation where actually you get, I'm not saying you engineer this, but if there is an angry matter, or you have a parish meeting and you record that there are angry people, then you're in a very good position to say, we can't pursue this any further. We know this is damaging to our mission. We've heard what people have got to say in our meetings. This is really why we can't stand here today and say, here's a checklist. If you do this, this, and this, you're going to be all right. Because it's going to be different in every single parish. Absolutely every parish is different. Some of you will find it very straightforward. Some parishes have already come to me and they've got practically everything that Brett talked about today, and they're going to be held to overcome. I know that David's got a piece to do. I'm sure you all have a long day and want to finish. The one thing I want to cover is, it came up briefly this morning, conflicts of interest. It is relatively commonplace, especially in small communities, that your lay rectors are either members of the PCC, or they are the husbands and wives of members of the PCC, or close family or friends. And it puts PCC members in a very awkward position. The duty of a charity trustee is not to do anything that may or may appear to put his interests at odds with the charity. So this may as much be about appearing to the public to have done the right thing as doing the right thing. If possible, and you have a lay rector who is a PCC member or who could be construed as having an interest, if it's possible to proceed in meetings and be quorate without them, they should leave the meeting. If the PCC decides that it is going to go ahead and register, then obviously that's fine, because that's all going to go ahead as it should. If the PCC decides that it has good reason for not pursuing chancel repair liability and registering it, then it should certainly get a ruling from the Charity Commission and explain that one of the members of the PCC, or however many they are lay rectors or have a connection with the lay rector, and get a ruling from the Charity Commission that they have made the correct decision. If, as was mentioned this morning, all of the PCC members, or the vast majority of the PCC members, seem to be qualified for making a decision, then that clearly is a situation where you need to get a ruling for the Charity Commission to explain why you're in difficulties in making a fair decision about this. I'm going to stop there. David is going to talk to us from the sharp end. David has been there, David has done the research, and David has dealt with his lay rectors, so I'm sure you'll find that very interesting.
Good afternoon, everybody. Can I just start off by saying that I was a little concerned when Caroline and Keith invited me to come along today to talk about the PCC's experience, because I knew it would mean my putting together some notes about a sequence of events from the dim distant past, something like 5 or 6 years ago. However, I must confess that as soon as I began to make the notes, the whole experience started flooding back. You could liken it to somebody who managed to bury his post-traumatic stress successfully, and then being forced to relive that significant life event. Maybe I'm exaggerating, but I can judge at the end. It's going to be difficult for me to summarise adequately in 15 minutes the research and activities into chancel repair liability which we as a PCC engaged in. And that was over a period of 12 months between May 2007 and May 2008. Also, I don't think I'll be able to convey in such a short time the intensity of emotions raised not only amongst members of the PCC, but also in the community. And that was the anxiety, the fear, the frustration, and all the frayed nerves. I don't claim to be an expert in the field, and my knowledge is limited to the experience gained as a member of the PCC at that time. I hope you forgive me, but I didn't know what to expect this afternoon. I didn't know whether it was just 6 people, or 2, or 3, or 4, or 5, but I put together a short script, so I hope you forgive that, but it was in the uncertainty of what to expect. Anyway, I'm going to divide my presentation into three parts. First, I'll just talk a little bit about the parish. Secondly, I'll talk about the research that we engaged in. And lastly, I'll talk about the final result, which was the calling in of liability, extinguishing it for good, and repairing the chancel, which was the objective. Okay, first, the parish. The parish of Lenting, St Peter, is a traditional, sparsely populated rural parish lying between Sweden and Grantham. It includes 3 outlying hamlets, Hamby, Casey and Osgoby, and the ecclesiastical parish covers an area of something like 2,000 acres. The church is a great long-listed building, dating back to the 13th century. The village has 62 properties, including a small number of local authority houses, 14 farms, and a total population of approximately 130 adults. The last major restoration of the church was undertaken in 1879, and by 2005 the fabric of the building was in urgent need of repairs. to the spire, the nave, and the chancel roofs. The PCC had been planning these major repairs for some time, following the architect's quinquennial survey report in January 2006. It sent out numerous applications for grant aid, and the estimated cost for the repairs was in excess of £200,000. Of this, the repairs to the chancel accounted for about £30,000. Over a period of a year, money from parish fundraising events, together with grant aid pledged by English Heritage, and support from numerous grant-making bodies, meant that we were able to raise a substantial part of the repair costs. Significantly, we noted that English Heritage's offer of support did not include money for the repairs to the chancel. Work began on an initial investigative survey as required by English Heritage in the summer of 2007. The contractor responsible reported that the spire was one of the worst conditions that they had seen, and it was in danger of falling down. We were given the option of either closing the church or having the spire temporarily reinforced. I mention this because the poor condition of the spire was later to play a very significant part in enforcing chancery liability. Having talked to one of the architects from English Heritage, I believe he's here this afternoon, she advised us that the repair project really ought to be completed in one job, if that were possible. When we first applied for a grant to English Heritage, one of the questions on the form was, do you have any erectors? And in our naivety, we ticked the box to say no, we didn't. Because at that stage, we confused lay erectors with licensed lay ministers. But since the chancel was excluded from the first round of offers of grant aid, we then suggested that we might want to consider applying for a second grant to English Heritage for the chancel. And when we looked at the application form, the same question was on the form, do you have any lay erectors? And this time, we were alerted from people in the village that, yes, possibly we do. We may have some lay erectors. But we weren't certain as a PCC what they were. And we knew about the potential problem of chancel repair liability, having read about the Aston Cantor case. But we never made the connection completely. And it was not until we attended a seminar organised by English Heritage for PCC's applying for grants that we became fully aware of the responsibility that lay erectors held. It was clear that English Heritage policy meant that grants from English Heritage would not be forthcoming if the parish or the church had lay erectors. So we began to consider the wider implications for the parish. This was one of those epiphany moments for us when we connected lay erectors, the Aston Cantor case, and the circumstances of our own parish for the first time. How naive could we have been, but there you are. So once related to what a lay erector was and the liability that was held, the PCC convened an extraordinary meeting to discuss the matter. At the beginning of the meeting, our then spiritual rector made a very impassioned speech to the effect that even if our church had lay erectors, chancel repair liability had no place in the 21st century and it was an anachronism. He argued that it was not in the best interests of the church or the parish to call on it. After a long discussion, a vote was taken and a majority present agreed not to call upon liability, but there were 2 abstentions. Since I was one of the 2 people who abstained from the vote, I didn't believe that the PCC had had full facts presented to it, and I undertook some further research. The research showed that chancel repair liability was, as you know, a significant asset, church asset, and based on the fiduciary responsibilities the Chancellor was interested in there. After further discussion with our rector, and in the face of this early research, he realised the wider implications and agreed that the PCC should undertake the necessary research to establish whether we had directors, and if so, precisely who they were. We were advised to rescind the earlier PCC decision not to call upon that liability. Okay, what was the research that we carried out? One of our first ports of call was to the License Office, where we examined the files held on the parish. There we discovered copies of numerous letters written by anxious farmers, residents, even the Ministry of Defence during the 20th century, all asking how they could commute this liability. So now, armed with a series of questions, we arranged to meet Caroline's predecessor as the Diocesan Registrar. We also read a great deal, we looked on the internet, and we consulted James Darion's little book that's been referred to this morning. All of this led us to the Lincolnshire Archive, where Mike Rogers' staff were most helpfully directed us to the Tithe maps and the record ascertainments. It was during a visit to the county archives that we experienced one of those eureka moments. This was when we examined the Tithe map and the records, and a reference to the fact that Lord Ancaster, the last great landowner of the district, who sold off his estate in 1913, was the lay rector, and indeed he received the great tithes. It was this point that really convinced us that we now had documentary evidence, and therefore proof that landowners in the parish did hold a liability for chancery repairs. But who were they, and who were the present lay rectors in particular? What was perplexing to us was that the Tithe map and the records seemed to cover only half the parish. We knew from the sales particulars that when Lord Ancaster sold his estate in 1913, it totaled something like 2,000 acres. The Tithe map and records accounted for only about 1,000 of those acres in the parish. Our next step was to visit the National Archives in Kew, and after ensuring on hand that the files we wished to consult were available, the IR-18s, the IR-29s that again have been referred to this morning. Our reasons for going there were threefold. First of all, to examine the original Tithe map and records of ascertainments to see if they match the copies held at Lincoln, to see if there were any transfers of land as a result of enclosures, and finally to see if the missing 1,000 acres to the south of the parish in the hamlets of Osgoby also bore any liability. This took nearly 2 days research, and in the event we finally obtained all the answers to our questions, and we ordered photocopies of all relevant documents. In obtaining the necessary documentary evidence bearing the seal of the Tithe Commission, it did prove that Lord Ancaster had indeed owned all the great tithes for the 2,000 acres in the parish prior to the breakup of the estate. Hence, those now owning the land held liability for the repairs to the chancel of the church. Probably the most significant find for us in the archives was sourcing a copy of a deed dated 1838, drawn up by an ancestor of Lord Ancaster, which provided for the merger of uncommuted rectorial tithes, and this accounted for the missing 1,000 acres. I'm sorry if I'm repeating something that you heard this morning, but when we looked at this and had it explained to us, it struck us as a really peculiar bit of legal metaphysics, which is that because Lord Ancaster's ancestor owned both the rectorial tithes and the 1,000 acres of land on which they were payable, then he commuted them. In other words, he had this deed drafted to commute them. However, these tithes have not been commuted into money payments earlier by the Tithe Commission in 1843. Hence, Sir Gilbert arranged for this tithes to himself. The crucial thing for us, though, was that although he could extinguish the payment of the tithes, what he couldn't do was extinguish the liability of chancel repairs. The significance of discovering this deed held profound implications for the half-dozen or so landowners in the hamlet of Osgoby. Because in the absence of a record of ascertainment, it meant that Osgoby landowners were both personally and separately liable for the full costs of the repairs to the chancel, which meant that any one of them, if identified, could be required to pay for the whole of the repairs to the chancel. It would then be up to that individual to reclaim shares from the other lay rectors in the parish. It was very different for the landowners sitting in the 1,000 acres to the north of the parish, where records of ascertainment clearly showed the limit of their liability, since the liability depended upon the size of the plot or the parcel of land they owned. To our horror, we now estimated that following the sale of the Enclosure estate in 1913, we were probably going to have to approach 50 or more lay rectors in the parish. These 50 lay rectors had been created over time as the land and farms variously changed hands down the decades of the 20th century. Finally, the result of all our research and the documentation was put to their diocesan registrar for a legal opinion as to whether the PCC could proceed and ask for the chancel to be repaired. This took us now to January 2008, and at last we received the news that the PCC could now proceed with confidence and acknowledge that we had a good case. Next came one of the most testing parts of the task, which was to identify all the lay rectors in the parish. We were helped in this by a member of our team who knew the local agricultural landowners quite well and the extent of those holdings. We also found that Google Earth was an invaluable tool, especially its measuring devices. We were astonished once the old Tithe map was compared with the modern Google image of the parish. It showed that the shape of the fields, hedges and ditches had changed little in 170 years. However, what had changed significantly was the position of individual properties and farm buildings. The question for us now was, once all the lay rectors had been identified, how should we approach them to present with our findings? I didn't go get it done. This is the last part, I promise you. While the research continued into identifying all the lay rectors, the PCC discussed the implications of the church in calling it in from more than 50 rectors. Following our rector's impassioned appeal, the chancel repair liability had no place in the 21st century. The PCC debated long and hard the arguments for and against calling on liability, especially the damage that it could do to mission and the role of the church in the community. After carefully weighing all the arguments, and in the best interests of the church, the PCC decided to explore the option of what is called compounding that liability. This would mean asking all lay rectors for a one-off payment to extinguish the liability and for all time. This option was then fully explored and discussed with the diocese, Andrew Gosling, who is the diocese trust and the estate officer. The option of compounding would secure the necessary money for the cost of the present repairs, if you're around about £30,000. It would also establish a sinking fund for future maintenance and repairs. In return for the agreement of the lay rectors to compound their liability, they would then be released from it. This would be formally recognised through a deed of release as provided for under statute in what is currently named the Ecclesiastical Dilapidation Measure 1923. At this stage, we believe that all lay rectors had now been identified. Letters and information sheets were distributed to all those identified, inviting them to one or two meetings. One meeting was arranged for the farmers and the large landowners, and the second one was arranged for householders. I have to say that at this stage, the community grapevine had been in overdrive for some time, and the PC was aware of the anxiety that the issue was causing in certain quarters. I think the letters of invitation for a meeting came as a petition of the Chancel, we then set out our proposals in presentation, and the first meeting was arranged with the farmers. This was a very tense meeting. We were listened to in complete silence, and the searching questions which followed showed a certain degree of hostility and scepticism as to our proposals. After all, farmers with large landholdings faced some substantial bills running into several thousands of pounds. Although the farmers did not challenge us directly during the meeting as to whether we had the legal right to proceed, we knew that they were already taking advice from their own land agents and from their solicitors. We knew our case had to be watertight before calling on liability. Before the meeting ended, it was impressed on everybody that in order for the compounding to proceed, it would require the agreement of all the lay rectors. In contrast to the farmers, the householders' financial liability was quite modest, and this was based again upon the size of the plots on which their houses sat. The surprising thing was that when we visited each of the farmers to talk to them on a one-to-one basis, they suddenly seemed surprisingly cooperative, providing us with access to maps and records or access to their land agents. Final figures were actually agreed based on land holding. When all the information had been collected and calculations made, invoices were raised, giving a period of 30 days for remittance. The PCC then held its collective breath. During the first week, after the invoices had been sent out, we had a trickle of remittances. But something rather extraordinary happened the following weekend. Our part of Enclosure experienced a considerable earth tremor. Suddenly, the following week, money started pouring. We learned later from one of the farmers that they were all worried that the spire might come crashing down onto the land, resulting in a repair liability rocketing to the full building costs of the Chancel, which then was estimated at £750,000. By the end of April 2008, all monies had been collected. The diocese finally issued deeds of release to all lay rectors on the 23rd of May. This allowed the Chancel to be repaired, at the same time to enable the spire, and a sinking fund was created, which is now invested by the diocese for future repairs and maintenance of the church. All told, the whole process remained being alerted to the significance of Chancel repair liability, researching it, and calling in the money had taken exactly 1 year.